sometimes needs to water.
Yeah. Oh, hold on just 1 second. All right, so are you already on Galvan? Orlando?
Yes, sir.
You ready?
Yes, sir.
All right, court is calling 2023 CR 108. Oh, are you, did something drop? You're okay?
That's a court reporter, Your Honor.
All right, court is calling 2023 CR 10854, State of Texas versus Bradley Galvan. Can I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense.
Orlando Castanon for defense.
All right, and you're Bradley Galvan?
Yes, ma'am.
All right, so my understanding, and hopefully this will be corrected today, that the name that should be in the indictment is Bradley Galan. Is that correct?
Yes,
That
All right,
is,
so how do you spell your last name?
Galan.
All right, so that needs to be corrected in the indictment. Let me look at the indictment and see if it's spelled as Galvan. In the indictment, it's spelled Galvan, so the indictments need to be corrected. Is there going to be an objection if the state decides to amend the indictment to include the correct spelling of the last name?
no, Judge.
All right, state, that needs to be done.
Yes, Your Honor.
All right, so now we're here on a motion to suppress and cause number 2023 CR 10854. It's the court's understanding that the court's ruling on this case, if I were to grant it, of course, then it will have repercussions as it relates to 2024 CR 0339. But for purposes of your motion to suppress, it's in regards to 2023 CR 10854. Is that correct?
Yes, Judge.
All right, defense, it is your motion. Do you have any witnesses?
No, Judge. We have provided the court with the copies of the affidavits for search. And I believe the state doesn't have any objections to that.
Correct, Your Honor.
All right, and then defense, I'm sorry, state, do you have any evidence you wish to present?
One bit of information to proffer to the court in the warrant affidavits generated by Warden Burkett. The warden specifies 6 longitude and latitude coordinates to limit the geographic area of the geofence request. The courts can use those location coordinates to determine the geographic area, but it would be easier for me to relay to you that Burkett already did that calculation and knows what it is.
All right, so are you offering into evidence those calculations or
Yes, sir.
the map?
As long as defense has no objection.
I believe the map is actually in the arrest warrant. I mean, the affidavit for search. But I have no objections as to the extent of the square footage.
Considering that Burkett informed me that the approximate area of the search location is 0.22 square miles.
All right, and you're in agreement that that is the length?
That is the total area, Your Honor.
All right.
Not the length or the width of both combined.
All right, and are you in agreement with that being the total area, counsel?
Judge, I do not know for fact if that is the square footage. I have no objections as to if that's what they're proclaiming it to be. I don't believe that that is what is at issue in this case. And so I have no objections if that's the square footage they're representing it to be.
All right, so state, do you have the actual photo of the area from Google Maps or someplace or no?
Yes, Your Honor, it is contained in the warrant application.
And I believe in the first warrant application, there is a geographical location with a map in it.
All right, so you all are offering that into evidence?
Yes, Judge.
Yes, Your Honor.
All right, so just make sure that is marked, and how's that going to be marked?
Be Defense Exhibit 1, if you like, Judge.
All right, Defense Exhibit 1, just make sure there's a printout for the court reporter.
Yes, Judge.
So Defense Exhibit number 1 is, for the record?
It is going to be the application for warrant That is CM 088445.
Could you repeat the CM number, please?
Yes, Judge, it's CM 088445.
All right, so that will be defense exhibit number 1. Any other exhibits?
No, Your Honor. Or at least not from the state.
There are other warrants that were requested. In regards to the geofence warrant itself, the warrant that is really a question is that CM number we just spoke of, but there are 3 other warrants that were filed or requested. There's 3 applications, and I can read those off. They relate to once the geofence warrants were granted and executed, they received information, and then the search became more narrow. But without the first warrant, they would not have been able to receive any of the information and would not have been able to apply for any further warrants.
All right, so your sole motion to suppress is based upon defense exhibit number 1?
It is, Judge, but I think just for the record, to be clear that we would also move to admit those other warrants as well.
All right.
And I have those numbers.
So defense exhibit number 1, and what is defense exhibit number 2?
That would be CM 097930.
And what is that exhibit?
That would be a search warrant, the application for search and a search warrant dated from April 1st, 2022.
All right, any objections to that state?
No, Your Honor.
All right, and then what is the next defense exhibit?
Yes, Judge. And then on May 5th, another application for search
Oh, everyone, please whisper.
was applied for and granted on May 5th, and that CM number is CM 098757.
And will that be defense exhibit number 3?
Yes, Judge.
All right. And then is there a defense exhibit number 4?
There is, I don't believe I actually listed that number in my, but I can pull that out.
What you've sent to the court in the email with the state included in an email, you have a 4th and 5th warrant as well?
There is a 4th warrant for search, and that's going to be related to the one we just spoke about was the residence. The 4th warrant would be the actually, I'm sorry, there's 5 warrants in total.
Mhm.
The 4th warrant was for a cell phone. That CM number is, we just spoke of, was a CM number 098757.
All right, so defense exhibit number 4 is the search warrant for a cell phone, correct?
Yes, Judge.
All
There
right.
is the affidavit for search, that would be the 3rd exhibit. And I don't know if I've got these out of order, which it sounds like I did, is a CM 098707.
098707,
Correct.
and that search warrant is related to what?
The residence.
All right, so defense exhibit number 1, that's the application for the warrant, correct?
Yes, Judge. For the
Defense
geofence warrant.
for the geo, okay. Defense exhibit number 2, that's a search warrant, correct?
It is, and that is for specific information regarding to my client's user information from Google.
Okay, so that's user info. And then defense exhibit number 3, what search warrant is that for?
That is for the that itself was for the, it looks like that was actually I thought it was the residents. They were. Yes, sir.
Might be a little bit easier if you borrowed my laptop.
All right, thank you. I just want the record to be clear what each item is. So let's start. Defense exhibit number 1 for CM 088445. That's the application for the geo warrant, correct?
Correct.
Defense exhibit number 2, which is CM 097930. That's the search warrant for his user information, correct?
That is correct.
Okay, defense exhibit number 3, that is also CM 097930. Is that correct or no?
That's 098707.
All right, 09807.
Yes, Judge.
That's defense exhibit number 3.
Yes, Judge.
And what is that exhibit?
That is,
Because I believe, off the record for a moment, I
Yeah.
believe you said that was the residence. Because I have defense exhibit number 3 as CM 098757.
yeah, that's just for the residents.
All right, so we're back on the record. So defense exhibit number 3, is that 098757?
That is 098707 for the residents.
All right. CM number 098707, which is defense exhibit number 3, is for the residents. And then defense exhibit number 4.
That is 098757. And that is for a cell phone.
That's the cell phone. And then defense exhibit number 5.
I believe that is to unlock the cell phone. Let me verify that.
Mhm.
Yeah, that's the information for his cell phone.
And that's the same CM number.
Yeah, that's going to be CM 100259.
All right. So defense exhibit number 1, it's the application for the geo search, correct?
Correct.
Defense exhibit number 2 is the search for your client's specific user information.
Correct.
Defense exhibit number 3 is for the search of the residence.
Yes, Judge.
Defense exhibit number 4 is, I guess, the seizing of the cell phone,
Yes, Judge. That was not at the residence, it was on his person.
okay, on his person. And defense exhibit number 5 is the warrant to unlock the cell phone and collect data.
Correct.
All right, so those are the 5 exhibits from the defense?
Yes, Judge.
All right, and then state, do you have any exhibits?
No, Your Honor.
All right, and if you all will make sure that those exhibits are printed out to be included in the record for the court reporter. And then with that being done, I will hear argument.
Yes, Judge.
Defense?
So, Judge, in regards to Mr. Galan, game wardens were called out on January 14, 2021 to investigate a scene where they found some dead animals or dead deer. And in part of their investigation, game wardens then sought search warrant in Exhibit 1. They sought to seek a geofence warrant, which gathers information within a specific location within a specific time. And so that warrant itself does not list any specific person. It is a dragnet. There's a 3-step process in regards to getting more information to find the specific user that they believe would be the suspect in that case. It's unsupervised. So when they did receive the warrant, they filed that request on April 26th. They were then given some information. They narrowed that information down to a smaller group. And then from there, there's a second step that Google law enforcement request systems requires, that they then narrow down their search request. They then give that information to Google. That is not supervised by a magistrate or any judge at all. They simply provide that information without any supervision. Google then responds to that. It will give them subsequently more information that is narrowed. And then the third step, they then review that information and then they determine as to who they believe that specific person is. After step 3, they then determined that they believe that Mr. Galan was the suspect in that case, and then they issued a second warrant, which is defense exhibit number 2. That warrant is for the user information on Mr. Galan, where they then gathered more information that they are using to allege then to receive a search of the residence where Mr. Galan was living. That was exhibit 3 in that search warrant. Then during that time, they searched Mr. Galan's house, where they believe they found contraband. And in doing so, they then ended up getting a search warrant for his phone, which was on his person, and then subsequently a search warrant for to unlock the phone and gather that information. Now, that's the background of the facts of that case. The Geofence warrant itself, though, is a dragnet. They do not ask or request information based upon a specific person. So there are innocent parties that they will end up receiving information that's personal and private. And so, that information is of innocent people. And so the Fourth Amendment prevents the government from, seeking information, being able to go into a person's private effects, and a person has a right to be secure in their person, their house, papers, effects against unreasonable searches and seizures. And so they need a warrant. The government needs a warrant in order to enter into anybody's personal effects, their house, residence, and such. And that has to be based upon probable cause. Now, the Fourth Amendment provides that no warrant shall issue without probable cause, and that the government has to particularize the place to be searched and the person or things to be searched, and that the Fourth Amendment requires a warrant to be supported by probable cause, that it describe the place to be searched and the things to be seized, and be issued by a neutral, disinterested magistrate. And if a warrant is invalid, the proper remedy in the criminal action is ordinarily to suppress the evidence derived from it. And so that's under United States v. Thomas. The probable cause demands that the law enforcement possess a reasonable grounds for a belief of guilt, particularized with respect to the person to be searched or seized. That's under Maryland v. Pringle. The Court of Criminal Appeals, Texas Court of Criminal Appeals, has found that the Fourth Amendment prohibits law enforcement of gathering warrants that are lacking in specificity, that the police may seemingly engage in general exploratory rummaging in a person's belongings. That's Walthall v. State. That's 594 Southwest 2nd 74. More recently,
Sorry, could you spell that name for the court
yes,
reporter?
Walthall is WALTHALL v. State. Now, and more recently, the United States Fifth Circuit in United States v. Smith, that's 23-60321, has held that these geofence warrants are actually general warrants. And they found that general warrants are not, and it has been longstanding law that general warrants are not constitutional. They articulated that these warrants are fishing expeditions occurring while law enforcement officials have no idea who they are looking for, or whether their search will even turn up a result. So similarly, in Mr. Galan's case, Texas game wardens did not know who they were looking for, nor did they know if their dragnet search would turn up any results. In requesting the geofence warrant, game wardens sought location information for all Google account owners who entered the geofence over the span of 36 hours. The warrant on its face swept in unrestricted location data for private citizens who had no reason to incur legal scrutiny. It's been recognized that a warrant cannot be obtained to search everything or everyone in sight. A warrant to search all persons present for evidence of a crime may only be obtained when there is a reason to believe that those present will be participants in a suspected criminal activity, and that's in the Owens v. Lott 372 South, Federal 3rd 267. That's out of the Fourth Circuit, Federal Court. That all persons, warrants can pass constitutional muster of the affidavit of information provided to the magistrate, supply enough detailed information to establish probable cause to believe that all persons on the premises at the time of the search are involved in criminal activity. So the Geofence warrant issued in April 26th of 2021 was used to gather Google user information on at least 72 people that had nothing to do with this specific alleged criminal activity. Then without supervision of a neutral magistrate or a second request under the same Geofence warrant was made to Google to produce data of a narrow subset of 13 users. That data was then used for a third request under the same Geofence warrant, again without a magistrate's supervision, to request data from Mr. Galan. Law enforcement then filed an affidavit search using information gathered from the original Geofence warrant to obtain a second search warrant on November 16, 2021 to obtain Mr. Galan's Google account information. And then again, on May 5th, they went into his residence with a search warrant. May 6th, they executed a search of that house and obtained a warrant for his phone and also again for the information in there. And as such, Geofence warrants are general warrants and not supported by particularized probable cause. Therefore, this search warrant was illegal, and that the information received from Google should be suppressed, and all evidence collected by law enforcement thereafter is fruit of the poisonous tree and should also be suppressed. I will note that in U.S. v. Smith, in the Fifth Circuit opinion, they found that the warrants were general. They did state in that opinion, though, that they did not suppress the evidence based on a federal rule of good faith, which is different than the state rule for good faith. And the Texas rule with code criminal procedures is 38.23B. And that it says a warrant, there's a good faith exception when a neutral magistrate signs on that warrant based on probable cause. And probable cause exists only when it is not based on a general warrant. So we'd ask that this Geofence warrant be denied as or be seen as inadmissible, and that it's an illegal search, and therefore all the subsequent warrants should be not admitted as well as evidence, and the evidence in Mr. Galan's case should be suppressed.
All right. State.
May I proceed, Your Honor?
Yes.
As a threshold issue, a request for location history data is not a search. To understand why we need to examine Carpenter, reasonable expectation of privacy that the court in that case elaborated, and how it is distinguishable from location history data. In Carpenter, the court considered two lines of cases. The first line addressed a person's reasonable expectation of privacy in their physical location. That line of cases included U.S. v. Knotts and U.S. v. Jones. In Knotts, the court held that visual surveillance augmented by a beeper hidden in a container did not constitute a search because the movement of a vehicle had been voluntarily conveyed to the public at large. In Jones, the court held that a GPS tracker installed on a vehicle constituted trespass. However, 5 justices concluded that longer-term GPS monitoring in investigations of most offenses impinges on expectations of privacy, regardless of whether those movements were disclosed to the public. The second line of cases discuss the third-party doctrine, which asserts that a person lacks a legitimate expectation of privacy and information voluntarily disclosed to third parties, and traces back to U.S. v. Miller. In Miller, the court ruled that a person does not have a reasonable expectation of privacy in bank records, since they are records of the bank over which the defendant cannot assert ownership. Similarly, in U.S. v. Smith, the court ruled that a pen register was not a search because a person who places a call voluntarily discloses the number he dials to the phone company. In Carpenter, the court analyzed cell site location information regarding these two lines of cases and concluded that people have a reasonable expectation of privacy in CSLI, cell site location information. The court reasoned that mapping a person's cell phone location over the course of a prolonged period of time provides an all-encompassing record of the person's location, considering that people tend to take their phones with them everywhere they go. Moreover, CSLI is collected without any affirmative act on the part of the user beyond powering the device. Finally, because cell phones have become, in the court's estimation, a ubiquitous and necessary aspect of modern life, it is not reasonable for a person to sacrifice having one in order to avoid being tracked. Because of their pervasiveness, the passive way in which they collect information, and the exhaustive and detailed amount of information they provide about the user, the court found that CSLI is distinguishable from a pen register of bank records, such that disclosure to a third party does not negate the reasonable expectation of privacy. However, the court went on to say that its conclusion was a narrow one, and it declined to express a view of other forms of electronic data collection, such as real-time CSLI, tower dumps, or other business records that might reveal location information. Which brings us now to location history data, which is distinguishable from CSLI in several ways. First, whereas CSLI is collected passively, a Google user must opt in to location data tracking. Moreover, even if a person has opted in, they can subsequently opt out if they choose, and can review, edit, or delete the collected information and stop Google from collecting more. Thus, a Google user must affirmatively consent to the collection and storage of location data, and can revoke that consent and delete the information if they so desire. Moreover, whereas cell phones are ubiquitous and necessary, location data tracking is neither. As far as ubiquity is concerned, the U.S. Fourth Court of Appeals noted in U.S. v. Chatry that 2/3 of Google users do not have location history enabled. As far as necessity is concerned, a person can still use Google products even if location history is not enabled. Activating location history might arguably make a Google product work better, but one can still use the product while opting out of location tracking. Because of these distinctions, location history data is more akin to the bank records and pen registers of Miller and Smith, respectively, for which a person lacks a reasonable expectation of privacy, and as a result, the disclosure of that information does not constitute a search. But let's say, for the sake of argument, that you are unconvinced and believe that location history data collected from a geofence request is a search that requires a warrant. The question then becomes whether that warrant was supported by probable cause, and particularly describe the place to be searched and the thing to be seized. First, a warrant is supported by probable cause if, under the totality of the circumstances set forth in the affidavit to the magistrate, there is a fair probability that contraband or evidence of a crime will be found in a particular place at the time the warrant is issued. It is important to remember that probable cause is a flexible standard that does not require certainty, it only requires probability. The Texas Court of Criminal Appeals in Foreman v. State has stated that it is not even a 50% rule. A fair probability will suffice. Moreover, the probable cause standard accommodates searches that may not turn up evidence and that may invade the privacy of the innocent. See Brinegar v. U.S., Illinois v. Gates, U.S., and Zurcher v. Stanford Daily. So in this case, Sergeant Game Warden True observed a deer that appeared to have been killed by an arrow. True followed the trail of blood left by that deer, and using his training and experience, which had not at this point been called into question, concluded that the deer had been shot at approximately the location where the blood trail began, which was a public right-of-way. True also determined, through his training and experience, that the deer had been killed within the past few days. Based on this information conveyed to Warden Burkett, Warden Burkett requested an evidentiary warrant which did not require probable cause to believe a particular person committed the offense. It only needed probable cause to believe that Google had relevant data that would provide evidence of the offense. Burkett did this by articulating the observations made by True, by describing Google's location history, feature, and storage policies, and noting that since the suspected location was used by other, presumably non-hunting people, potential unknown witnesses to the crime might be located. Second, the warrant sufficiently described the place to be searched and the thing to be seized. Since the warrant did not authorize search or seizure of a person, no description of a person was necessary. Under Bonds v. State, A warrant is sufficiently particular if it enables an officer to locate the property and distinguish it from other places in the community. Moreover, a court may look to extrinsic facts in determining whether the language in the warrant is sufficiently particular. In this instance, the place to be searched was Google's records for its electronic consumer data pertaining to location histories limited by the particularities of the geofenced area and relevant time frame. Similarly, the warrant particularly identified the thing to be seized. In this instance, the thing to be seized is the data itself, which is likewise limited by the specified geofenced area in the relevant time frame. Now, defense counsel cites to the Fifth Circuit's decision in U.S. v. Smith. Particularly, the circuit courts claim that such warrants are fishing expeditions occurring while law enforcement officials have no idea who they are looking for or whether the search will even turn up a result. Well, with all due respect to the author of that opinion, they fundamentally misunderstand the purpose of search warrants and the probable cause standard. Once again, the probable cause standard for a search warrant does not require law enforcement officials to have some idea of who they are looking for. It doesn't even require them to have an identifiable suspect. See Dominic v. State. Similarly, it does not require them to know that a search will in fact reveal evidence. The probable cause standard only requires a law enforcement officer to demonstrate to a neutral magistrate that there is a fair probability that a search of a particular place will reveal evidence of an offense. But there is a much bigger problem with the Fifth Circuit's reasoning in Smith, because that court held that all geofence warrants, no matter their particularity, are general warrants because the data set is so vast. This seems difficult to reconcile with the Supreme Court's holding in U.S. v. Carroll, in which the court explained how to draft a warrant for the installation of a location tracker in physical space. The court wrote, "It will still be possible to describe the object into which the beeper is to be placed, the circumstances that led the agents to wish to install the beeper, and the length of time for which beeper surveillance is requested. In our view, this information will suffice to permit issuance of a warrant authorizing beeper installation and surveillance." The warrant problem in Carroll is similar to the warrant problem in Smith, which is similar to the warrant problem here. The place to be searched is basically everywhere the location tracker could conceivably go on the face of the planet. But the court found a way by specifying the place to be searched as the object into which the location tracker would be placed, the particularity being satisfied by the amount of time of surveillance. Moreover, Smith is difficult to reconcile with Carpenter itself. After all, in Carpenter, the court opted for a rule that warrants are necessary to search CSLI. But CSLI and location history data do share one thing in common. They are essentially stored in huge databases. If this court adopts the Fifth Circuit's reasoning, then this court endorses a rule that a warrant is sufficient, except when the database is massive, which amounts to a rejection of Carpenter itself. But let's say, for the sake of argument, that you are still unconvinced. In that case, 3823B still does not require the suppression of evidence. As the Court of Criminal Appeals noted in McClintock, an officer who reasonably believes that the information he submitted in a probable cause affidavit was legally obtained has no reason to believe that the resulting warrant was tainted. In executing the warrant, that officer acts in objective good faith reliance upon the warrant as long as the warrant is facially valid. Thus understood, the language of Article 38.23b is consistent with the application of good faith principles to excuse a prior illegality and thus renders an officer's reliance on a neutral magistrate's assessment of probable cause objectively reasonable. Accordingly, we hold that the good faith exception of Article 3823b will apply when the prior law enforcement conduct that uncovered evidence in the affidavit for the warrant was close enough to the line of validity. As an aside, I love that phrase. That an objectively reasonable officer preparing the affidavit for executing the warrant would believe that the information supporting the warrant was not tainted by unconstitutional conduct. In other words, and to sum up, if an officer acts in objective good faith reliance presents evidence to a neutral magistrate, the neutral magistrate determines that there is probable cause and issues the search warrant, then the evidence collected as a result of the warrant should still be admissible, even if the neutral magistrate's determined probable cause was retroactively determined to be incorrect. So for two reasons, you should deny the motion. It's not a search. The geofence warrant is not a dragnet. For a third reason, even if you choose to uphold the motion, the evidence collected as a result of that search warrant should still be ruled admissible.
All right. Any response?
Yes, Judge, two things. One, in the cases he cited, and especially in Carpenter, there's a difference in those cases. They actually knew of the suspect they were seeking to get information on. In this particular case, they didn't know whether they were even going to receive any information. It was a guess that they might receive information within this geographical location. And so in Mr. Gallan's case, they did a dragnet. They just asked for everybody's information within a specific time and this specific place. When he speaks of Carpenter, that case deals with an individual who was an accomplice in a robbery. That information was received from an individual who had been arrested and gave information regarding Carpenter's participation. And so they actually knew and were able to particularize who the warrant was for and what information they were seeking. In this particular case, Mr. Gallan's case, that is not what they did. They did do a dragnet. They sought any and everybody's information without even knowing whether they would find any information, whether they would find any data. It was a guess. And secondly, the state is positioned that the federal good faith exception applies in Texas, and it does not. In the federal good faith exception is based upon not whether the warrant itself was based on probable cause, but whether it would prevent law enforcement from seeking these illegal warrants in the future. And so the standard he's trying to assert applies in Texas, it does not. And because of that, we ask that you grant this motion to suppress.
Okay. And it's the court's understanding that this is an issue that is being taken up in the appellate courts?
It is being taken up by the Court of Criminal Appeals here in Texas, and as well, and I could provide you with a brief, and I can provide the state with that brief and the.
Oh, I've read it.
Okay.
Okay.
And as well, because there's, I think, a division in the federal courts, the Supreme Court may also be taking up this issue.
All right. So this is what the court is going to do. I'm going to reset this matter. I've heard both parties' arguments. I'm going to reset it for December 19th. It appears to the court that economically it would do no good for this court to make a ruling on it if the appellate courts decide something different. So we'll have to wait and see what the appellate court's ruling is, because they are an authority that's higher than this court, as is the Texas Supreme Court and the United States Supreme Court if it goes there. So we're going to see where they are on December 19th. Sometimes it takes a while for them to issue their opinion. So is there any objection to either side to the court resetting this for December 19th? And I'm saying this, of course, for purposes of speedy trial issues.
Yes, Judge, I don't have any objection to that.
All right, so this will come back on December 19th, and we'll see where the appellate courts are at on this situation. And on that time, state, if you can make sure that if there are any changes to the indictment with regards to names, if that could be taken care of as well. All right, thank you.
Thank you, Judge.
Thank you, Your Honor.
You're welcome. All right, Medina. All right, Mr. Hobbs, if you can unmute.
President, Your Honor. Sorry about that.
No problem. So have you all decided, or do you all have an agreement on the motion to revoke, or you still wish to proceed with the bond?
We're working toward that, but we don't have any resolution. So I think at this time it might be best to move forward on the bond. Tony and I will continue to confirm between now and next week.
All right.
I will
So
keep
this
Mr.
is,
Medina's testimony very brief in lieu of the fact that we're coming back to it.
all right. The court is going to go back on the record in 2018 CR 1860, State versus Nathan Medina. If we're going to have parties announced for the record for the state.
State of Texas.
Defense.
Colin Hobbs for Mr. Medina, Your Honor.
And are you Mr. Medina?
Yes, ma'am.
All right, the court had heard testimony with regards to setting a bond in this matter and defense. Did you have any other witnesses to call?
Call Nathan Medina at this time, Your Honor.
All right. Any objection to defense counsel appearing by Zoom state?
Your Honor.
All right, Mr. Medina, can you raise your right hand?
Yes,
Do you
ma'am.
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Nathan Deshawn Medina.
All right, defense.
Mr. Medina, you've heard the
I'm sorry.
testimony from your
Just one
fiance. That,
second, Mr. Hobbs, just one second.
yes, Your
Counsel,
Honor.
counsel, if y'all can move to that end, just let the deputies know. All right, we're back on the record. You may
Mr.
proceed.
Medina, you heard the testimony from your fiance this morning. Regarding your brothers, can you give the court a little bit more information regarding how they came to be in y'all's care and custody?
Yes, sir. So, I grew up very unfortunate. Never really had good role models in my life. My brothers always meant everything to me. My mom went to rehab, unfortunately, and still going down the gutter. And with that being said, I decided to take my brothers in so they can go to school because they weren't going to school. And I was like, you know, that's not right. Like, I want them to go to school and do right and live a right life and not follow the path that I was in right now, currently, that I'm trying to get out of. And I figured that with that, taking them in, that would help them with their future. And I'm just doing the best I can, changing my life up. And I know it looked bad on paper, but that's not who the man I am anymore. And I'm ready to rewrite that all and fix it all up. And I got my brothers with me now, and I'm thankful for that. And I have a newborn baby this January 9th, and I'm thankful for that. And with that being said, I'm just grateful to have them in my life and them be with me instead of on the streets.
And you have a baby daughter that's going to be born soon. Are you hoping to maybe be out for that birth?
Correct. Yes, sir. I want to be out before the birth so I can witness that. And it'll be a blessing, a huge blessing to me and my family. We would highly appreciate it.
Now, obviously, you heard testimony earlier that your fiance and you're okay with paying for the GPS. Y'all can afford the $300 per month.
Yes, sir. I can't afford that. I currently work and I cut hair for a living, and I can't afford that. Yes, sir. That's
Okay.
no.
And then from there, are you asking this court, should they grant you a bond with GPS to allow you to go to work so you can continue working to support you and your family?
Right. I would love for the court to grant me that so that I can continue to provide for my family, because I'm the only one that they have currently. I'm also looking after my other little sister, but she's staying with another relative as well. So I have a lot on my plate. My family highly needs me right now, and whatever the court can grant me, I would highly appreciate that.
One of the things the court's very likely to do is have you do frequent check-ins. Are you okay checking in with pretrial services?
I'm capable of doing that as well. Yes, sir.
Okay. Any objections to if the court makes you pee in a cup on a weekly basis? Will you comply with that?
Yes, I can. That's perfectly fine.
Is it fair to say that anything the court asks you to do, you're going to do so?
I'm going to do it 1000%.
All right,
Yes,
so
I'm fine.
let me just tell you, whenever people say put something at 1000%, it's normally not true. Whenever you see Maury Povich shows and they're asking, are you the father? When the mom says 100%, we're like, yeah, he's probably the father. But when the mom says, oh, I'm 1000%, you know what always ends up happening? They're not the father. So never go to 1000%.
Yes, ma'am. I will comply, though. I will comply.
Understood. Is there anything you wish for the court to know at this time?
I just ask that you guys grant me this and trust within me and my word that I will own up to what my wrongs were and show and prove to the court that I'm willing to be a man now and prove to you guys that I can do what's right.
And obviously, you're charged with having not succeeded in your probation. Have you made strides within the last several years to turn your life around?
Yes, I have. And before in the past, like I said, I wasn't smart. I wasn't making any wise decisions. I didn't have anybody saying, hey, like, like you need to do better or anything like that. And now that I'm getting older, I'm getting closer to God. I'm actually getting closer in my faith. I'm actually wanting to go do the sobriety thing with my mom and help her with that and just do better with my life because I have that opportunity. I have that chance, just like everybody else has that chance. And yes, I am making better decisions. I don't do really much besides cut hair and go home.
Is Eris and her family, have they been kind of a blessing as far as helping you get right?
Oh yeah, they're a huge blessing and they're very motivating people. Like I said, their military background as well, and they're very, very strict and they love me. They love me and they support me a lot. And they're the ones who actually wanted me to come over there and live with them because I was deciding to go live in a hotel and they said, no, we're not going to allow that. You're going to stay with us and we're going to get your life figured out together. And they're very, very supportive with that.
And they know what you're charged with and they're still going to support you through this time?
Yes, they do. Yes, sir. They do know what I'm charged with and they are very still supportive and they're not ever going to not be supportive.
I'll pass the witness.
All right, so do you have any other witnesses?
That's all, Your Honor.
What is happening with this Valverde case? Is that
Our
still pending?
Our understanding, Judge, from his conversations with his attorney on that, I don't believe it's still open. The state can certainly speak to that if they've had a chance to look it up. My client says that he was a passenger in a vehicle.
No. Here's the thing. I'm not trying to get into any facts that are in the NTR. I just want to know if that case is still pending.
His belief is that it's not, but I don't have confirmation of that, Your Honor.
Does anybody know?
You don't see the Valverde case in Odyssey, Your Honor. Answer the court question. I don't know what's going on with the Valverde case.
All right, so before the court sets a bond, I need to know if there's a Valverde case. Does anybody want to pick up the phone and call the DA's office in Valverde to see if that case is open?
I can try, Your Honor. Logistically, it'd be difficult for me. I'm, as the court's aware, in it.
All right, the state is going to check and see.
Perfect. Thank you.
All right, just have a seat. We'll get back to you.
Yes, ma'am.
I can tell you this can move slowly out there.
Okay. Do you need a number, state?
I was gonna try Google, Judge, but
Okay.
do you have a better number?
830 775 0505. All right, counsel, we'll be back with you.
Thank you, Your Honor. I appreciate your time.
You're welcome. I'll put you in the waiting room. Who's here on Michelle Garzas? All right, if you'll come down. We're back on the record on 2020 CR 2289, State of Texas versus Michelle Garzas. Can I have parties announced for the record for the state?
Andrew Harris, Sadelman, standing in for Jason Garrett.
Defense?
Luis Martinez on behalf of Ms. Garces.
All right, so I gave you two choices. Which do you choose?
And Judge, if I could just prevail upon the court again to consider alternate resolutions. Once again, if I'd ask the court to give her a UA today, and if she's clean, I think that demonstrates that maybe sending her to safety would be not what she needs. It might be a waste of resources at that time. Because obviously she's got a very demonstrated mental health issue. And I think that that needs to be addressed. And if we're not getting that addressed, then I don't think that she's going to be successful down the road regardless.
Okay.
And so, like I said, I'd ask the court to just to consider that because I don't think it's, just a rampant substance abuse problem. I think that she has underlying mental health issues.
All right. And so what I said before is felony drug court would address all of that. So you have two choices. You can go to prison. I'll revoke you because you have been missing for a while, or you can go to safety. Those are your two choices. Which do you choose?
How long was the prison? What was the prison?
Or 3-year prison. Or so you probably everybody.
Ma'am, I was hanging out with the wrong crowd. I never been in trouble before.
Okay, let me just tell you something. You know who the wrong crowd is? If the people you were hanging out were here before me with a motion to revoke, they would say that they were hanging out with the wrong crowd. And then I would ask them who that is, and it would be you. When people say they're hanging out with the wrong crowd, you are a part of the wrong crowd. So
Yes, ma'am.
you were placed in felony drug court, and I want you to internalize what I'm saying. Felony drug court has a dual diagnosis program where they will help you with mental health. They'll help you with drug issues. They will get you clean and sober. And once you're clean and sober, they'll diagnose the mental health issues you may have. But if you run away from the program, there's nothing they can do. And according to your motion to revoke, you have been missing April, May, June, July.
But-
You were missing.
And Judge, would the court allow her to explain what happened that got her off track in felony drug court?
Oh, sure, she can explain what happened, but you have your two choices. It's either it's getting revoked or you're going to safety. Those are your two choices.
Well, I had got COVID as well too, so that's why too I was out for so long as well. And when I was in Laurel Ridge for about a month, and they sent me to Wimberley, Texas as well. So this is why all those months I was missing. It was not because I was running or anything like that. I was just trying to get my mental state focus, trying to figure out.
And what I'm telling you is felony drug court was trying to help you with your mental health treatment and your drug treatment, and you're not there. So you have two choices. You can be revoked or you can go to safety. Those are your two choices. You made a choice, and your choice was to leave, and you've been missing for these many months. Unless you were in ICU in a coma,
Well,
You're
I had
either-
COVID. I had COVID. I couldn't be in front of anybody or go to the courts or anything.
you left felony drug court. You left.
I didn't leave, ma'am. I went to Laurel Ridge. I didn't leave. I went that next day to Laurel Ridge. I didn't run away from it or anything like that. I didn't.
Okay, you have two choices. And those are your two choices.
And Judge, another concern I've got is that she is in a Social Security appeal that she's almost done with. Obviously, it's gonna be difficult to get that process ended with her being over at safety.
Mhm.
And that is good, that's gonna be necessary for her getting funding for treatment in the future. That's gonna be necessary for her to fund her her SSDI. And so for those reasons, we also ask the court to consider not sending her to an inpatient, allowing her to be on a leg monitor,
Outpatient.
outpatient services, mental health services, to continue going through Center for Healthcare Services, which is what she's doing right now and seems to be working for her situation.
All right, you have two choices, prison or inpatient treatment. Which do you choose?
I can't have outpatient or something.
You have two choices,
I don't know.
prison
I would
or
go-
inpatient treatment.
Inpatient treatment. You get out about the same time.
I don't think- What should I do now? So I get the treatment? I don't know.
No, here's the thing, time out. this is not like The Price is Right where you turn around and ask people what's the
Well, I
best
just
choice.
asked you my
No,
own-
here's the thing. You can't ask other people what's the best choice for you because guess what? At the end of the day, your mom is not going to be doing time at the prison. She's not going to be doing inpatient treatment. It's 100% you. Now, if you need some time to sit in the box and discuss things with your attorney, you're more than welcome to do so.
That's-
But it's your choice you got to make. And if you don't make a choice by 3 p.m., I'm going to make the choice. So I'm giving you a choice, prison or inpatient treatment. Those are your two choices. There are no other choices on the table for you. Do you understand?
Yes.
All right, so you all can have a seat in the box and you can discuss things with
Yes,
her.
ma'am, thank you.
All right, thank you. All right, Michael Egu. Good afternoon. All right, so we're here for discovery. Where are we on discovery?
Judge, I believe discovery has been provided, at least everything that, I can download everything that's up on the system, and I haven't noticed that there's anything.
All right, and has an offer been tendered?
It has not, Judge. I think the state is waiting, needs a little bit more time in that regard.
May I explain the situation?
Yes.
First of all, sir, how do I pronounce your last name? Ugu. Ugu? Mr. Ugu is currently on probation for an aggravated assault and deadly weapon. There is an assault process server with an offense date of March 28th, 2023. That case was filed at Warrant. It had still not been indicted when Mr. Ugu entered his plea on the ag assault and deadly weapon. Now it's been indicted. And what I'm trying to learn from the ADA who handled the plea on the ag assault deadly weapon was whether or not this assault on a process server was supposed to be taken into consideration for that plea, because I don't find any notes from that ADA indicating one way or the other. Now, I've asked this ADA and he is looking into it.
All right, let me ask you this. Did you look at the court's file to see if something was written in the notes in the court's file?
No, I have not.
All right.
Judge, I can represent to the court, there's nothing in the court. in that
You've
regard.
looked in the,
Yes, Judge, we were completely unaware of this case at the time that, at the time of sentencing and even at the time of the plea.
all right, and what is the case number for the case that he's on probation for?
Give me a moment to look that up.
Okay.
I have Marco bringing it.
All right, thank you.
It is 2023 CR 7389.
Let me see if there's anything in Odyssey.
Did we have Odyssey back then, Judge? Was it?
No, I'm reading the notes that I have because I put notes on everything in
Okay,
Odyssey
okay.
now.
I was just wondering if Odyssey was even running at the time.
You're right, it wasn't in there because what I have in Odyssey is that the number one, this predates the motion to revoke. So I'm assuming it wasn't taken in consideration because if it was, I would have put in the notes that it was taken in consideration.
But there's, I apologize for interrupting, Your Honor. There's also no indication that we are supposed to proceed on this assault on a process server. There's no indication one way or the other.
No, there isn't.
So I would like some clarification because obviously TICing this case into that plea would be better for Mr. Hu.
And who was the prosecutor who was on this?
Our dearly departed Daniel Escalon.
Okay, Don't say dearly departed like he's, no longer with us on the planet.
He left, Your Honor.
All right, so we will recall this. How much time do you need to speak to the dearly departed?
Your Honor.
Would it
I'm
be
gonna
by
need
Ouija
to find
tips?
a medium, a sale, a Ouija board, it's gonna take probably.
All right, you all want to bring this back on the 31st
No.
or
Judge.
later? Well,
Later.
no, he's saying he would have the information. Will you?
No, I
have it?
understand, but the 31st would be, if we could do the week after that, Judge, I appreciate it.
That's fine by me. It'll also give me an opportunity to follow the assault process with.
All right, Ms. Ferguson, put this on November 7th. All right, we'll see you back on November 7th.
Thank you, Judge.
Thank you.
Judge Rudy,
All right, just give me one moment.
whenever the court is.
Well, it's open, so I don't. It may be revocation, may not be revocation. Don't want one anyway? Okay, okay.
All right. Michelle Garces. All right, we're back on the record in 2020 CR 2289. Ms. Garza, what do you wish to do? I'm sorry?
The safety.
All right. Court will deny the motion, alter and amend conditions to include safety. Probation, is there anything else she needs? Extend for how long? And extend 3 years. Is there anything else?
I mean, obviously, Judge, if she comes out and she's doing better, we can talk to the court about
Yes.
the length of that, right?
Yes.
Okay.
All right. Thank you.
Yes, sir.
Jose Amador? All right, on this case, we just need a jury trial setting,
Judge.
correct?
Already a discovery acknowledgement on file.
There should be.
Let's see. I do not have one in the file that is the endangering of a child or the aggravated assault. I don't have one in the court's file. I'll say that.
Please tell me Mr. Amador's signature. If you have it.
Sure, just give me one moment. 118-9918. So how long do you expect this trial to last?
Probably 4 days, Judge.
4 days?
There's a number of witnesses,
Okay.
and so I believe we probably would be going to punishment to the jury.
All right, Ms. Ferguson, I need a jury trial date, 4 days.
Mr. Castaneda, please don't believe the discovery of options.
All right, you're gonna come back on December 2nd for jury trial. Your plea deadline date has expired. The court will not consider any plea bargain agreements with a good cause. Otherwise, you have to plea open to the court. You'll be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to let your attorney know, and they'll do a clothing exchange. Counsel, if there's an issue with the clothing exchange, just let the court know.
Yes, Judge. I will say that I do have a vacation letter for December 9th and 10th. I'm flying out on the 6th to Colorado, and we have non-refundable tickets and
We'll see where
stay.
we are.
Okay, Judge.
Yeah, I'll make sure you make your flight.
Thank you, Judge.
Unless somebody from your family tells me, Judge, we really don't want him there.
No, I doubt that. It's my daughter's birthday. We're going to
Oh,
see a Santa run.
oh, that's so nice. All right. Is there anything else?
No, Judge.
All right, thank you.
My wife's best friend is his cousin, so I'll find out if you want.
Yeah, let me know.
I don't say that on social media, but. Okay, that's fine. I can show you the plane tickets. Show you the rental. The RVO. That should be fine. You don't wanna- No, I'm not running. We're not running. But they also line up. Oh, right. So we've gone, but it's always what's happening. Order earlier. Order. We've gone. Was that on that? At least started. We have passed. Yeah.
Luis Martinez? All right.
My kids are.
All right, what is happening with this case?
Mr. Villarreal?
No, Luis Martinez.
Is all excited about that, right?
So Luis, oh, I see why you're saying that, Luis. You're like, I'm still here. You know, when I keep calling your name. Who's the attorney for Luis Martinez? Is he on the docket? I don't see him on the docket, Luis Martinez. Ramsey Ibrahim? I have two files. Sure. Christopher Munoz, we've already done that. Guadalupe Rodriguez. Hello, how's it going?
Good.
Usually you're in Colorado or somewhere else trying some
Nice
case.
to be home.
Yeah.
But right now, when that came in, I'll talk it again, he signed up to come in,
Yes.
and they brought the files.
Okay, so we have an issue. And you see what date is in there?
And I have that. Yeah, remember. For jury trial.
Let me make sure it's in Odyssey, so I can put a note in Odyssey. I'll check
Might
that.
have been.
Okay. All right, so what is happening with Mr. Rodriguez?
Good afternoon, Judge. So Judge, we have a possible disposition, and then right before we did the plea check, we found out that Mr. Rodriguez has a new case on indicted.
Mhm.
The ADA has emailed the responsible attorney to see if they're going to go forward with that case. I don't know if we can call this in a week or two to give them time to do that. We still may have a disposition, but if they're going forward, it may complicate it a little bit.
You want to call it for the 31st?
That'll work, Judge.
All right, Ms. Ferguson, Mr. Rodriguez is coming back on October 31st. All right, thank you.
You know, while I have you, if this isn't a good time, just let me know. I've got an off docket matter that I want to handle, talk to the court about real quick about a case that was on a docket last week with a visiting judge. I have a case number. It was a first setting and we were.
Just 1 second. Let me put this in the system.
Certainly.
Okay, what's the cause number?
Well, on reflection, Judge, talking to the ADA, you're probably going to want me to have my client here for this, so maybe I'll ask you.
Okay, sure, no problem.
Thank you.
You're welcome. Oh, sir, just have a seat in the box.
Thank you.
Are y'all ready on Medina? Or is Tony still out on that?
I believe Tony is still out here.
Okay.
Yeah, he's on the phone.
All righty. And then Celestino Garcia.
Over to the front. For the mic check. Then, there you go.
And state on this one, are you all going to be proceeding on the First Amendment motion or no?
Question, Your Honor. Yes.
All right, court is calling 2023 CR 2522, State of Texas versus Celestino Garcia. Can I have parties announced for the record for the state?
And Fair Assembly.
Defense.
Robert Ramirez for Mr. Garcia.
And are you Mr. Garcia?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes,
Did you understand it?
yes, ma'am.
Are you the same Celestino Silly Garcia who's placed on deferred adjudication in 2023 CR 2522 for the offense of unauthorized use of a vehicle on May 11, 2023 for a term of 3 years? Is that you?
Yes, ma'am.
State?
In Bear County, Texas, the defendant Celestino Celia Garcia did then and there fail to report to the supervision officer as directed for the months of May and June 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State?
State waives the remaining violation allegations, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
Number 4, Your Honor.
I'm sorry, number 4.
Yes.
All right, the court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, deny the motion, continue probation, amend for the following. Extend 6 months, GPS tracking for 6 months, complete reporting for 30 days, and MRT, moral recognition therapy. And the state will take into consideration clause number 2024 PF 18478, and one last thing, no contact with Palacia apartment homes.
All right, so 2024 PF 147.
18478.
Okay, why should I follow this agreement? I mean, he's not reporting. That's like one of the easiest things to do, to report. Not only is he not reporting, but he picked up a new offense. I don't understand. What's so hard about reporting?
Your Honor, he got off the rails a little bit with his support system. He was tied with a church group, a men's church group that helped him along the way. But he's trying to do as much as he can for himself on his own. And he tried to find a place to live. He was at this apartment complex.
No, but he was supposed to reside at Victory Gospel Chapel. That's where he wanted to reside. That's where I ordered him to reside. So why is he leaving a place that I told him that's where he's to reside?
I don't know.
Did anybody do a trial court certification of defendants' rights to appeal?
No, Your Honor, I didn't.
All right.
This says that so you'll have a right to appeal if the court does not follow your agreement. Okay.
court does follow, then you'd have to get the court's permission. Yeah. Okay. Yeah, right, sure.
Okay, so for me to sign these, I need you to attach the trial court certification to it, because I don't know if he granted them the right to appeal or not. So if you attach the trial court certifications, then I'll sign it. All right, so why are you not living where I told you to live?
To be
You want to
honest,
raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
You can lower your hand, state your name for the record.
Celestino Celie Garcia.
Why are you not living at the Victory Gospel Chapel?
Around that time, I had gotten to an altercation with a brother, and I had got released from the program.
All right, and did you call probation and tell them that?
Yes, he knew that I was moved.
No. My question is, did you call probation and tell them, I've had an altercation at the residence that the judge told me to live? Did you call them and tell them that?
No, I didn't tell him that I had an altercation.
No, you just left.
Whenever I left him, I had probation the next week, and then I told him whenever I got there.
But you just pled to not reporting.
No, I reported that time, but then after that, the last time that I left the church, that's when I stopped going after I left the church.
Okay. All right, the court is finding violation of condition number 4 true, taking in consideration 2024 PF 18478. The court is going to grant the motion. Court will find you guilty, revoke. Does anybody want to talk about time?
I would like to, Your Honor.
Yes.
Which time? This time, and not previous time. About 30 days. Your Honor, we'd asked to, on the court's discretion to, under section 1244 of the Texas Penal Code, to sentence him to no more than 1 year in the Bexar County Jail. He's going to have a felony conviction, Your Honor. He has, and he's got a lot going for him to go to, if he goes to state jail, that's going to be, day to day. At least he'll have a sanction. He'll have the conviction, and then when he gets out, and I ask you that you give him no more than 6 months, Your Honor.
All right, state. He's asking that his client be sentenced under 1244.
I don't know anything about the circumstances of the offense, Your Honor, so I'm not really in a position to intelligently state what amount of time should or should not be considered.
All right, do you want to familiarize yourself with the steps?
If the court will allow me, I would love to, Your Honor.
All right, you may proceed. And just have a seat in the box and we'll get back with your case. Hello. All right, who's on Matthew Villarreal? And are you the prosecutor on that? You can go ahead and,
I can do two things at once, Your Honor. Can I go there?
okay, yes, come down. And there's no application on this case?
No, Judge, a straight time offer.
Court is calling 2024 CR 00921 State versus Matthew Villarreal. Can I have parties announced for the record?
And you accept state.
Meredith Chacon for Mr. Villarreal, Your Honor.
And are you Mr. Villarreal?
Yes, ma'am.
Counsel, you received all of the discovery?
Yes, Your Honor, as far as I know.
Did you review with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Villarreal, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir, Your Honor.
Yes. Mr. Villarreal, did you review the court admonishments with your attorney?
No.
Did you understand it and sign it in all the appropriate places? Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
No.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
No.
Oh, Let me,
I don't-
I'll rephrase it. Did you intend all of the rights that I've just explained to you? Did you intend to give them up and enter into a plea bargain agreement?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor, and I've been able to communicate with him in a way that he understands the big words we use in the paperwork. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Villarreal, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Ma'am.
According to the plea, punishments be assessed at 3 years in the prison. There's an affirmative finding of the deadly weapon and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Be contained in Exhibit 1 and attachments, Your Honor.
No objection, Judge. I had to go over the attachments for my client.
Uh,
All right, state, you may be excused.
Thank you, Your Honor.
Mr. Villarreal, did you review the stipulations with your attorney? Did you understand them?
Ma'am.
Did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we'd like for him to get time that he's already got credit for. I believe he's got several months of that time.
All right. So what happened on this day?
I also wanted to know if I had a back time for the other.
Just for this case.
Okay, no,
Yes.
no, it's fine.
All right, so what happened?
To be honest, I don't remember, ma'am. I was drunk and I was on pills and
Okay,
I was under the influence.
all right. All right, the court will find you guilty. The court is going to sentence you to 3 years in the prison. There's an affirmative finding of affirmative finding of deadly weapon. Give you credit for any time served. There's to be no contact with Ezekiel, Ezequiel, Limon, Limon. And I'll order the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. but it will help you if you have any type of mental health issues or any type of alcohol or drug issues.
Thank you,
I can't,
Judge.
you're welcome. I can't force them to place you in the program because I don't have the authority to do that. So you are going to have to request it. They'll see on the judgment that I've requested it for you, but you have to request it as well. Do you understand?
That for ma'am? Like,
If
Like,
you have,
yeah.
yeah.
Like you
Rehab.
asked me if there was a way you could get some kind of treatment. Judge is recommending they do that, but you need to make sure and ask when you get there that that's what you want as well. Okay? It doesn't increase your time. Okay, yeah, yeah, okay.
Okay. All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? And did you sign it?
No.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal,
I'm sorry.
because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. It looks like you have a knot or something underneath your neck. You need to make sure the doctors check that out.
I don't know. I thought it was my Adam's apple now. I don't know what it is.
Yeah, you need to have the doctors check that out and tell them they need to check it out immediately. You understand?
Yes, ma'am.
All right, good luck to you.
That's the certification. of the appeal. That's it.
What if it is,
But they don't need it, that's, don't worry. Yeah.
But you still need her?
No, we're done.
Come on, guys.
Let me see. I think I do. So that's that one.
See you, Master, Your Honor.
Yes.
Mr. Hobbs.
Okay, just give me 1 second. I don't have April. Let me just double check. I have Nathan Munoz. Celestino Garcia, Calandras. No, I don't have April. All right, so Tony, you ready on Medina? All right, we're back on the record in 2018 CR 1860, Nathan Medina. And state what information do you have?
After speaking with both Martha and Cindy from the DA's office, they searched his name, both spelling Nathan, Nathen, as well as Nathan, and the date of birth, and they could not find any case.
Okay. All right, and does he have any other cases?
Does, Your Honor.
And what are these other cases?
It's a Bear County case for failure to identify.
Okay. All right, is this going to end up being a contested MTR?
We might come to an agreement between now and the date. Tony and I will continue to confer, but it feels like at this point that probably it will be contested.
All right, what bond amount are you requesting, state?
State is requesting $30,000, Your Honor.
Defense, what type of bond are you requesting?
Judge, we were requesting 15,000 with any conditions that the court felt was appropriate.
All right, court will set the bond at $15,000. Partial GPS for employment only. There's to be no employment as a home health care provider with minors. Any other conditions that are being requested?
No, Your Honor.
All right. Norma, if you can give him a reset form for October 31st, state you'll need to be ready for a contested hearing on that day.
Sure.
All right, thank you.
Thank you, Your Honor. Have a great day.
Thank you, you too.
Have a great day.
All right, you too. All right, is there anything else?
If we're not that is filed.
Okay,
I need to approach on something off docket.
sure, just give me one moment.
Judge, I think should have put my file up there, but it's here pending on the docket.
Okay, who is your client?
Arco, I can never see it.
And
All right, just give me one moment.
Your Honor, we need to continue with Celestino Sealy Garcia.
Yes. That's not my fault.
I think so. I agree with you, Bashan.
I'm not passing germs. All right, Celestino.
Yes, Your Honor.
All right, we're back on the record in 2023 CR 2522, State versus Celestino Garcia. Where we left off, defense was requesting that his client be sentenced under 1244. State, do you have any objections?
No, Your Honor.
All right. Are you asking me to sentence you under 1244?
Yes, Your Honor.
All right, I'll sentence him under 1244, but it'll be to a year.
Yes, Your Honor.
All right, are you waiving your right to appeal?
Yes, ma'am.
All right, the court will sentence you to 1 year in the Bexar County Jail under 1244 and give you credit for any time served. And as previously stated, the court has taken in consideration 2024 PF 18478. Going to show you what's entitled Trial Court Certification of Defendant's Right to Appeal. Did you review that with your attorney? Did you understand it?
No.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
No.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
No.
All right, we can go off the record. Whatever drug issues you have, if you don't take care of those, one or two things are going to end up happening. One, you're going to lose all your brain cells because that's what drugs do. Two, somebody's going to find a body on the side of the road or in a field, and somebody's going to have to come out and identify that body, and that's going to be you. Or three, you're going to end up spending a majority of your life in prison. You got to decide how you want your life to be. Do you understand?
No.
There are plenty of places here in San Antonio where they have free drug treatment for you. When you're released from the Bexar County Jail, if you can't find a place to go, if you come back here, I direct you to a free place, okay?
No.
All right, good luck to you.
Thank you.
You're welcome. See, I thought it was up here, but I didn't see it up here.
I could have sworn I printed it out this morning, I guess.
No, I think you had, but I don't know where it is. I was looking at the docket and saw that that person hadn't come in yet, the attorney.
I was having a message for you.
Yeah.
Coming in for recess.
Well, so let me see. I'm gonna double check again.
Judge, on Mr. Baker, 'cause I know that one would get funky. Are we only issuing the judge's warrant on that PF case? Or are we doing
Yes.
that case?
No, just on the PF case.
Just on the PF case?
Mhm.
Okay, I just want to double check. Thank you, Judge.
All right, you're welcome.
Got it. I don't have it. Let's see, right? Six spreadsheet. My God.
Yes.
First of all, thank you for letting us here, please.
Oh,
I
no,
appreciate that.
no problem.
Judge, that's on Austin Young. Mr. Young, who's continued about a month ago, he had lost his PAM device.
Mhm.
You put him on scram. We haven't had any violations.
Mhm.
He is not feeling very well mentally.
Mhm.
And so he is looked into some mental health treatment for 45 days. The family can pay for it. They're willing to do that. There's a letter from the facility that they will accept him. And so I've talked to the state and they're okay with him going as long as he,
Have you talked to probation officer?
yes,
And,
there was no objection for anybody's stuff.
okay.
State's okay. They just want him to stay in touch with probation. And it's a kind of a dual diagnosis place, but it's mainly that, because he does have some underlying substance abuse he's had to deal with. But mainly he's just not feeling very well mentally.
All right, he's still gonna have to do his testing though.
Yes, ma'am. Well, he does testing through his places too.
That's what I'm
Yeah.
saying.
And he's got the scrambling machine on. We're gonna keep that on, so.
Okay.
Yeah.
All right, let me put this in the system.
Yeah, like I said, I wanted to thank you for humoring. You continue to
No.
ask for it.
No problem.
Yeah, I knew it was gonna happen, but they have to think that I'm fighting for them.
It happens.
Yeah.
Let me see.
I mean, nobody wants to win, right? Nobody wants.
No. Agreed.
They bought that. No.
Mm-hmm.
Now. Yeah.
All right, here you are.
Thank you, Judge.
You're welcome. All right, April Pettis.
Present, Judge.
All right, and counsel, I know you were recently placed upon this case. Ms. Pettis, have you had any contact with the attorney that was previously appointed to represent you?
Just my mom, I told my mom to contact them. She said she got a hold of him. Something about he was gonna be out of town or.
All right, so we're gonna go on the record. The court is calling 2024 CR 2756, State of Texas versus April Ann Pettis. Ms. Pettis, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Abraham Pettis.
All right, there was an attorney that was previously appointed to represent you. Had you personally had any contact with that attorney?
No.
All right, and are you asking that Mr. Castellon be appointed to represent you?
Yes.
All right, and for the record, you are?
I'm Orlando Castellon.
All right, and so Mr. Castellon, I know you were just appointed to represent
Yes, Judge.
Ms. Pettis. So I'll give you a 30-day reset, give you a chance for him to have discovery. If he wants you brought back over sooner, he can let the court know and we'll put you on the docket sooner. Do you understand?
I will be filing a motion to set bond. I believe she's been remanded without bond. She said she was not aware of her prior setting, so.
All right.
There any chance that we could get that kind of set?
Sure.
Then, Your Honor.
Do you want to bring, not tomorrow? We
Yeah,
can bring her
I'm
back.
actually not gonna be available tomorrow.
I mean, we can set it for sometime next week if you want to set it for next week.
Okay, that's fine, Judge. I'm available next week.
Okay.
That's fine.
All right. So we'll bring you back on October 28th.
Okay, thank you, Judge.
Thank you.
You're welcome. Norma, if you can make sure she comes back on the 28th. Yes.
Thank you.
As part of Mr. Celestino Garcia's plea.
Okay.
You didn't have a card for him?
Yeah.
And
you.
you-
He's getting.
Pardon me for a moment, I'll take this. To the office.
Yes,
Thank you, Your Honor.
you're welcome.
The wonderful world. Number 13. Oh, okay. Come on.
All right, who do you have?
Marco Berlindes. MTR and a DWI third.
All right, let me see if I have that MTR up here. All righty, let's bring him up.
You're the preview judge. It's gonna be a plea of truth, an explanation, and no read recommendation.
All right, I love previews. It's like the trailer, right?
The problem with the previews is I tend to go through all the pop-ups. I have nothing left for the movie.
But you know, I always try to be there for the previews because if the movie is horrible, you can say, well, I can look forward to these other movies. I remember mom took us to see a movie and it was Clash of the Titans, the one with Harry Hamlin.
Oh, the graphics are horrible, but it was a great movie.
No, at the time the graphics were great.
What?
And let me just tell you, that guy who did that, his graphics are still great because Sinbad, the sailor, all of those graphics are still great.
Great Harryhausen.
Yes, but when we were there, you know what, when we were waiting for Clash of the Titans, you know what the preview was? Raiders of the Lost Ark.
Oh,
And so my mom would take us to the movies probably like once every 2 or 3 weeks. But that was the time she said, we're coming back the next Saturday and we're seeing Raiders of the Lost Ark. But it was great. Those were the days. All right, court is calling 2023 CR 3508, State versus Marco Antonio Calendres. Could I have parties announced for the record for the state?
Andrew Harris, Edelman.
Carl Alexander for Mr. Colindres.
And are you Mr. Calendres?
Yes, Your Honor.
All right, did you review the document entitled Motion to Revoke Community Supervision and First Amendment to Motion to Revoke Community Supervision with your attorney?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Are you the same Marco Antonio Calendres who was placed on community supervision in 2023 CR 3508 for the offense of driving while intoxicated third or more on August 24, 2023 for a term of 4 years? Is that you?
Yes, Your Honor.
All right, state.
For about the 10th day of December 2023 in Bear County, Texas, the defendant Marco Antonio Colindres did then and there consume alcohol in violation of condition number 2.
All right, how do you plead to that? True or not true?
True. State waives the remaining violation allegations.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, sentence you to 4 years in the prison and a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
Your Honor.
Court will find violation of condition number 2 true. What are you requesting, state?
Revoke supervision, assess the underlying sentence of 4 years.
And defense, what are you requesting?
Judge, we're asking that you deny the motion, that you continue him on supervision, and my client is asking for help. So in our discussions, and part of what I was doing during court is reaching out and seeing if it's even possible. He is a veteran. He continues to struggle with some unresolved PTSD issues and obviously substance abuse as well. I spoke with the state earlier this morning and this afternoon, kind of looking into his criminal history. It is a true DWI third. My client does acknowledge that he does have an alcohol problem. You will see, I'm sure, on the First Amendment motion, there was a new number 1 out of Travis County. That case, per my client, has been rejected or dismissed.
And what is that case about?
Apparently when picking, may I, am I allowed to tell her? Okay. So in executing the court's warrant for the MTR, he decided that he was going to flee initially when he and his cousin were stopped, which is really an evading. It's still a new number 1. I get that, but it's alleged as an escape. My understanding is Travis County has declined to go forward on that. Mr. Garahan did a TCIC, NCIC over the lunch break. There's no prosecution available, so I have no reason to disbelieve my client about the resolution of that case at this point. Mr. Colindres was going through some financial troubles, Judge, because I was trying to ask some of the questions I figured you'd probably want to know.
Well, this is what I want to know, because I'm not the one who placed him on probation. Another judge placed him on probation. So probation on Colindres. Has he ever had any treatment? Because what I see the other judge wrote, well, all he wrote was 2 year, I think it was Judge Harrell, all he wrote was 4 years probation, $1,500 fine, 2-year license suspension, 10 days in the Bear County Jail, GPS, TAP, 150 hours community service restitution. That's it. So has he received any treatment? Bec-
Today, no, there was a top evaluation completed, intensive outpatient was recommended back in December of 2023. I would, that was it. There has not been any.
All right, so this is what the court will do. The court, you have a choice. I can't give everybody choices. Here's your choice. One, we can refer him. You're saying that he's a veteran?
Yes, Judge, he's per him and he does have his DD 214 available. His mother would have to provide it because he's in
Well,
custody.
have you seen it?
I have not seen it, Judge. I have no
Do you
reason.
know 100% that he's a veteran?
I only know what he's represented to me, Judge.
Does anybody have the report? Was there a PSI done? Are you saying you're a veteran?
Yes, Your Honor.
What branch?
United States Air Force.
Just 1 second.
No, if I was.
Do you know if Veterans Treatment Court, can you call somebody from there to see if they can at least see if he was in the military?
Judge, I don't know that they have, immediate access to it. I can ask Mr. Herman to come down.
Yes, if you can ask him to come down. All right, just have a seat.
She showed me that. I was like,
All right, sir, if you'll come down.
no.
John, thanks for running down.
Of course, Judge.
All right, so on this case, he's never had treatment before. It's obvious that he needs treatment. I didn't take his plea, so I wasn't unaware. I didn't know he was military, so I wasn't aware of that. Defense is saying that he says he's military. He's saying he's military. Of course, as you know, we need proof that you're military. So how long would it take?
So we were speaking, Your Honor. I can say the conversation we had, he couldn't have held with me if he didn't serve. So he did give me his reentry code. Unfortunately, you okay if I share it? Fortunately, he can't ever rejoin the military.
Okay.
He did have a few different issues that we kind of talked about. He reports he doesn't have any of his paperwork. So I was speaking with the attorney and him, it's the fact of I can make a call, and it was also the finding point of can call and confirm whether someone is or isn't. So now's the time to tell me. The problem is going to rely on the fact of I will run with it pretty quickly as far as I can go. We have set up an opportunity to where right now there is a Zoom possibility that we can have between the three of us or even his mom. His mom is here in town. If we get him registered on My Healthy Vet, because right now he has not touched the VA system.
Okay.
If we get him registered there, we can expedite it to where we can get the paperwork that we need. However, we'll know tomorrow if he's telling what he's saying is true. And I'll start the eval process as fast as we can, push him through for felony VTC. When we get to the staffing table, which can happen every Thursday, we have docket. I'm trying to think of logistically here. Probably within 2 to 3 weeks, we can have him at the staffing table. The state of Texas, part of the DA's office, is that we're gonna have to show something. If I can show that he's registered, it's approved, the fact that we've confirmed it through military records that he served, what he's telling me, other than honorable, the reentry code, security forces for about, I apologize, about a year and 6 months, and unfortunately got chaptered out. We can work with that. And then we can ultimately, when the VA, you know how the government works, Your Honor, sometimes it takes a little longer for them to print out a paper and hand it to them. Once we get that, we'll just add it to his file. So it's really just how fast we can get him registered with the VA, which we can do as quick as we can get him on a Zoom call.
All right, so here's my question. So is that something that can be done while he's in custody or no?
Which part? The registration part?
Well,
or the eval parts? The
the
evaluation
eval.
part? Yes, we can run right now. I have given him my business card. If you choose to take the route of signing the referral, Your Honor, I will give him the instructions of what to mail me. He can do it while he's in his, unfortunately in his cell, he can write it out, he can send it to me. It's really at the point of registering is whether or not his defense attorney and himself are willing to set up a Zoom call for us to get in, which right now I'm assuming we can do. He's on board with.
I'm willing to do it, but the requirements the jail has on doing that, the soonest they'll be able to do it would be Monday.
Correct,
You have
yeah,
to
so
do
then we're working with the jail requirements, Your Honor. So yes, I'm on board to do it. If that's the route the court would like to choose, we'll work within the parameters that we
All
have.
right, do y'all want to have him brought over on Monday? Would that make it easier for things to be accomplished or no?
What the thing we would need to do would be registering him, like, well, it's a computer system.
So if you're the.
I mean, theoretically, like, let me take my
Theoretically.
calendar. I could sit in here with my laptop on the defense Wi-Fi and sit in the box with them in.
Okay, if that's easier for everybody to do, it can be done that way.
Or, actually, Judge, I have court tomorrow. I'll be in the courthouse tomorrow morning. If it's not too late, sorry, guys, if it's not too late to order him for tomorrow, just for the purpose of me able to sit down in the box with him and do the registration.
We could request no original promises because it's after.
Yeah, I know.
3:30.
Yeah. I
So
know.
all right, they'll request him and we'll see what
So
happens.
fingers crossed.
Yes.
I'll bring my laptop just in case.
All right, it is Marco Calandras. So we can go back on the record. We're back on the record in 2023 CR 3508, State versus Marco Antonio Calandras. Court has found violation of condition number 2 true. The court will deny the motion because it appears that you have not been given treatment. Court will alter the main conditions to include a referral to the VTC. If he's not accepted in the VTC, then there'll be a referral to felony drug court. And he's to remain in custody until transferred to VTC or FTC. Is there anything else?
No, Your Honor, thank you.
All right, is there anything else you need?
No, Your Honor, thank you.
Herman, is there anything else?
Your Honor, I'll keep you updated.
All right, thank you. Thank you.
Thank you, Judge.
All right,
No big excuse.
yes.
See.
Bashan,
Okay, see you tomorrow.
on Saturday, Bashan, I will be here. Yes, there are some students who are coming over on Saturday to view the courtroom. So I will be here. Yes, do you want to come in on Saturday? Deputy Laura, Deputy Mejia, can y'all have somebody brought over for Saturday since I'm gonna be here anyway?
Of course not, Judge.
Yeah.
Do people know that you're bringing this class since they have to be screened before coming in?
Yes, they do know.
Okay.
So Judge Ramon used to always threaten, if we didn't finish this trial, then we're gonna come in on a Saturday when I was her prosecutor. But she delivered on it one time.
Oh, yes.
This one, E3 and Tochi